everybody, my name's Nicoletti. I'm an attorney in Jacksonville, Florida. Today I want to cover some classic scenarios you find in the probate market, the probate industry, and the probate real estate niche that a lot of you are interested in, want to dive in, maybe you're already in, but I want to cover some of these classic scenarios. And a lot of times people ask, what is it? What's involved? The basics to it is that there was someone, they owned real estate. They can own other personal properties, bank accounts, but in the world of real estate, they owned real estate, they died, and in order for the heirs to either get title to the property or to sell the property to a buyer, investor, or just get the property sold, you have to go through this process called probate, where the title is then transferred to the heirs. It's a court process to get it transferred, and then once it's transferred over, the heirs then can sell it to the buyer, investor, whoever it is. But that is a classic scenario that has to happen where somebody on title, they died, they owned real estate, and to transfer it to the heirs, you have to go through probate. The other issue is pre-foreclosures, foreclosures, reverse mortgages. Now that's an interesting area a lot of people don't realize with probate, is you'll find that somebody owned real estate, they died, and the heirs want to transfer the property to themselves, but the deceased actually had a mortgage. And that mortgage isn't going away just because somebody dies. The bank is then going to want to make sure they get the money and or get the property to get the property sold, so they get the money they got from the note. So what's the problem here? Well, in a foreclosure, pre-foreclosure, or a reverse mortgage, I have an adage. The only reason that somebody has stopped paying and is foreclosed is they forgot to pay, they can't pay, or they're dead. Huge lead source is the foreclosure area. Be careful of reverse mortgages because there is a pretty high payoff. They're never on point with the payoff, and you got to just be careful about what it is and what's the number. Or you may get a motivated seller that says they want to sell the property. You didn't know anything about who owned it before. You get under contract with them. You say, hey, this is going to work out. Let's do this thing. Let's go to closing. You go to the closing table and you find out, or get the title commitment back and says, we need to do a probate here. This is not happening. The underwriter, title insurance company, is not going to write a buyer's policy until a probate's done. Another classic scenario. Or maybe you get the referral from a friend, a neighbor, somebody that knows somebody that passed, that owns real estate. They are really confused. They have no money themselves, but they know mom, dad, grandma, grandpa owned the real estate here in Florida. Or you may find the person that owned real estate in Florida resided primarily in another state, like they resided in South Carolina, they resided in Georgia, they reside in Washington, another state they reside in, and they owned real estate here in Florida. And then you have an interesting scenario because that's called an ancillary probate if the probate has to be done here, which is a whole other video. But that's something to be aware of. Also, you may come across vacant homes, vacant housing, vacant land. What has to happen there? I mean, it's considered non-homestead if it's vacant land, but you still have to do some kind of probate process, another classic scenario. Or the one that I've seen so many times in my career and profession is 3 days before the closing, the underwriter comes back and says, well, we can't do anything. We found out that the person that owned the real estate is dead, and now we have to do a probate. I've jumped in on those before, but knowing that that's another classic scenario, there's probably many more that have happened to you that you can imagine, but it's important to know some of the basics.